Hello and welcome back to Fraud in America. I'm Jackie DeMar. Today I have with me Ben Schiffrin from Better Markets. They recently released a report on the SEC's Whistleblower Program is key to protecting the economy and street American wallets, and has lots of really good information about the SEC Whistleblower Program. Happy to welcome him today to talk a little bit more about that program and about the report. Thanks for joining us, Ben.
Thanks so much for having me.
So can you give me maybe just a little bit of background on kind of the kinds of fraud that are policed by the whistleblower program at the SEC, and just the kinds of fraud schemes that we see coming in there?
Sure. I think the whistleblower program really covers all the different varieties of fraud that the SEC itself covers, so that includes financial frauds, accounting scandals, insider trading, market manipulation, things of that nature. And so the whistleblower program is just designed to help the SEC prosecute those types of frauds.
And it appears that as potentially the government a little bit, maybe some people at the SEC and the SEC whistleblower program and enforcement maybe the office may be getting smaller, so that emphasis sword in the private sector seems to be potentially even more important now.
That's exactly right. And that's one of the points that we make in the report. You open the newspaper every day or go online and read the newspaper every day, and there's another story about cuts to the federal workforce. And now there's been reporting that those cuts are going to reach the SEC. The SEC's enforcement division is the biggest division at the SEC, and it's the one that's responsible for investigating and prosecuting the types of frauds that we were just talking about. So if the size of the SEC's enforcement division is diminished, and is diminished significantly, it's going to be way more difficult for the SEC to identify violations of the securities laws, identify instances of corporate misconduct, and bring the wrongdoers to account. And so, one of the things that may become increasingly important if those cuts come to fruition is the SEC's whistleblower program. Because what that program does is incentivize individuals at the wrongdoing companies and in the marketplace who know about violations or potential violations of the securities laws to come forward and bring it to the SEC's attention. And the program has been very successful, putting aside whether it's going to be more important because of cuts to the federal workforce, because the SEC is small in relation to the market that it oversees. It has 5,000 employees, which sounds like a lot until you appreciate that it oversees the $100 trillion capital. It's
Right.
And so 5,000 employees just isn't that much. 13,000 registered advisors, broker dealers, public companies, et cetera, et cetera. It's just vast. And so the SEC, even as it stands, is underfunded. And so it relies on this whistleblower program, which incentivizes people to come forward and report wrongdoing to the SEC to identify securities violations. And that will become increasingly important if the size of the SEC is diminished.
Right. And the number of tips that are coming in have been increasing year over year, including up tips from around 18,000 last year. Right. So it seems like even more whistleblowers are potentially coming forward, but also the need for that office to stay robust seems more important now than ever.
That's exactly right. It's certainly true that we've seen an increase in the number of tips year over year recently. And I think that's attributable to the fact that the program isn't even 15 years old. It took a while for it to get up and running. It took a while for people to understand how it works. But at the beginning, it proved its worth. It proved that it was very successful in identifying misconduct, holding wrongdoers accountable, and getting money back to the victims. And so over time, I think people realized, hey, this program is really very beneficial. And so you'll see an increasing number of tips coming into the program. I think as of last year, it reached 100,000 tips for the lifetime of the program. And one of the reasons that staffing at the SEC in the enforcement division and in the whistleblower office specifically needs to be maintained is that as more tips come in, you need people to, go through the tips, because of course it's not like you just submit a tip and a case gets brought and you get an award through the program. Somebody has to go through the hundreds of thousands of tips that come in, identify the ones that are meritorious from the ones that aren't. Then the case first has to be brought. Then the SEC first has to obtain relief. And then there first has to be a determination of what amount, if any, the whistleblower deserves. And so obviously with 100,000 tips, you could imagine the SEC needs a lot of staff people to go through all those tips.
Right. Absolutely. So let's talk a little bit about the numbers. You mentioned that hundreds of millions of dollars have been returned to the government or be to the shareholders throughout the life of the program. And last year, I think there was the third or fifth highest amount of awards paid out, but that is responsible for bringing potentially billions of dollars back in revenue, right?
That's right. That's right. So think that the program is responsible for leading to successful enforcement actions that have totaled over $6 billion in monetary sanctions in some combination of disgorgement and civil penalties. And that has led to, really billions of dollars then being returned to investors, because a large percentage of the monetary sanctions that is collected by the SEC gets returned to the wrong parties. And the program has given out about $2 billion to the whistleblowers that are responsible for submitting the tips, providing the information that has led to the enforcement actions that have allowed the SEC to obtain about $6 billion in monetary relief.
Right. And the SEC also goes after companies in trying to impede whistleblowers from coming forward, and they're continuing to do that in pretty full force, right?
That's exactly right, and they've done it increasingly so in the last 2 years. There are actually a number of provisions in the law that are designed to protect whistleblowers. One is an anti-retaliation provision, which isn't the one you asked about, but it's important to bear in mind in the scope of the program that because whistleblowers are putting their careers on the line really to engage in this whistleblowing, and in a lot of respects, they can be shunned from the industry in which they work if their identity is revealed. And sometimes, of course, the companies know who the whistleblowers are. And so the law says you can't retaliate from somebody for whistleblowing. And both the SEC and the individual, him or herself, can bring actions in court to enforce these anti-retaliation provisions. So that's one important part of the program. The other one, which is the one that you asked about, is there's a provision that prevents companies from impeding whistleblowing. So the retaliation is after the whistleblowing has taken place. The provision about impeding whistleblowing is before the whistleblowing. And that says companies can't do anything to prevent, more or less it says that companies can't do anything to prevent their employees from bringing whistleblower complaints to the SEC. And recently the SEC we've really seen an uptick in the number of cases that the SEC has brought when companies have tried to impede their employees from bringing tips to the SEC's attention. Usually it happens when they ask, the employees to sign some type of an agreement that says, I'm not gonna, disclose potential violations that are taking place in the company to the SEC. And that's a pretty stark example of something that the companies, aren't supposed to do. Because of course, if every company was able to get their employees to sign an enforceable agreement like that, it would be impossible for people to bring these complaints to the SEC's attention.
Right. And these aren't small penalties necessarily. I think Schiffrin had to pay $18 million last year in one of these cases. And there are more cases, again, that, like you mentioned, that are continuing to be brought. So, and we expect that to continue going forward. There are some ways we could probably improve the program, right? So one of the things you mentioned in the report is just increased transparency with the whistleblowers, because they can bring them anonymously with a lawyer representing them, or they can bring them in their name. But either way, if there's no communication with them or their lawyer about what happens after the tip goes into the SEC, that can be frustrating of reasons and lead to a lot of angst on the part of the whistleblower who doesn't know what's going on. Can you talk a little bit about some of those improvements you might want to see?
Sure. I think that a lot of the firms that represent whistleblowers will say that the lack of communication with the SEC can be frustrating because there can be a long lag period between when they submit the tip and, a case is brought. And the whistleblower, is probably pretty nervous about having tried to blow the whistle. And if they're not kept in the loop, that can, exacerbate the stress that they're already experiencing. So that's an important point of the communication. But an even more important point, it has to do with the mechanics of the program. The whistleblower will, go to the SEC and, submit a tip or a complaint, what have you, an allegation that something's going wrong. And then there is this presumably long lag period, not just for the SEC to investigate the complaint and tip, but if it's meritorious, to bring the case, right? Litigation can take a long time. So there's that lag time. But then the whistleblower award, even if there's a successful enforcement action, the whistleblower doesn't automatically get an award. What happens is the SEC will post what's called a notice of covered action saying, we brought this case successfully, satisfies the statutory requirements for a potential award, one of which is the SEC had to obtain over $1 million in monetary sanctions. So we're talking about the bigger cases. If you feel that you deserve an award as a result of this successful enforcement action, you have to submit an application for an award. And so, I think that whistleblower advocates are fearful that a meritorious whistleblower would have done everything right. They would have submitted the tip. It would have led after months or years to a successful, sizable enforcement action, but then not realize that they have to go through this process, that they are the ones that the SEC is talking about when they're posting this notice of covered action. And so I think that if there was greater communication, it might prevent meritorious whistleblowers from missing out on awards that they really deserve.
And you also mentioned in the report that there's a need for the public to be more aware of the program, but also more aware of the benefits of the program. And they see a big award getting paid out, but they don't maybe take into account what the whistleblower did to get to this award. As you just mentioned, it is extremely risky for people to come forward and report these things. And not only that, they bring very important information that they see just would not have had the whistleblower not come forward. And that it leads to those sanctions dollars that we talked about before. Can you talk a little bit about how you think the public could be better informed about what whistleblowers are bringing to the table here?
Yeah, so this is tricky because it is very important to protect the confidentiality of whistleblowers. The reason that we talked about before, they're putting their careers on the line. One of the fundamental features of the program is anonymity. Whistleblowers would be far less likely to come forward if they thought their identities were going to be revealed. And so the SEC, the way the program is designed is it's designed to maintain the confidentiality of the whistleblowers. They can't disclose any information that could lead the identity of the whistleblowers to be revealed. So that's why the SEC's orders saying we're granting a whistleblower award to this person are often heavily redacted. I think the problem, though, is that they're so heavily redacted that it's almost impossible for the public, for anybody reading this notice of an award, which is, of course, the only thing the public would really know that transpired is that whistleblowers getting this award, to know what happened. We were talking at the beginning about the SEC in general and the whistleblower program more specifically helps reveal financial frauds, insider trading, market manipulation. Those are things that I think the public would care about, and I think the public would appreciate knowing that, hey, this whistleblower stopped a financial fraud. This whistleblower stopped a market manipulation. This whistleblower stopped, a company from cooking the books. But it's impossible to tell from these orders, even really what was the crime that was committed that the SEC stopped. And so I think the SEC should think about how it can do a better job of letting people know that, hey, there's this program. We're not just giving whistleblowers money for no reason. We're doing it because it really led to this tremendously important result. Yes, the order usually maybe says, we were able to obtain a successful monetary relief, but it doesn't really say why or what the case involved or why it was so important. I admit I'm not exactly sure how to do that and still protect the really important anonymous nature of reporting, but you can imagine the SEC Whistleblower Office comes out with annual reports every year, maybe on an aggregated basis, like, hey, these are some of the really important,
Exactly. Yeah.
financial crimes that the whistleblowers helped us uncover. Just some way so the public really gets a better understanding of what's going on, because, I think we put in our report an example of really this like very heavily redacted report award determination in a case that led to really significant monetary relief for the SEC. But just by reading the award, you really wouldn't appreciate what a big deal it was for the SEC to have been able to bring this case that it otherwise wouldn't have been able to bring absent of.
Yeah, absolutely. And it is tricky because that anonymity is so important. What you just said about like an aggregate report or something like that, it makes a lot of sense. Like on a yearly basis, they would have to report to Congress or whatever that, whistleblowers held in X amount of dollars in sanctions and stopped, X number of Ponzi schemes or whatever it was. A little bit more information, I think, would be really beneficial for people to understand how important the program is.
Exactly.
There's also, sorry, excuse me. There's also been some kind of criticisms of the program by some people that, there's certain attorneys that have previously been at the SEC and they're the only ones bringing these successful cases. And, this is a problem because. And so can you talk a little bit about that criticism and kind of like your counter arguments to that? Because I think they're very good ones.
Sure. Yeah. As you said, the criticism is that it's somehow problematic because people leave the SEC and then go to represent whistleblowers. And so the whistleblower program is somehow just a way for post-SEC lawyers to, have clients. I think and I think that's unfair for a couple of reasons. The first is that people leave the SEC all the time and go into private practice. And it's desirable for law firms to be able to say, we have this former SEC person that can help you, the client, navigate any troubles that you have with the SEC. In fact, it's commonly considered a problem that there's this revolving door between people who work at the SEC and that go into private practice. Nobody objects when the clients are able to hire the big law firms and have been able to hire all these former SEC people. That's just kind of considered, the way it works. Well, why is it a problem for people to leave the SEC, go into private practice, but it just so happens that their law firm practice, instead of representing, corporate defendants, represent whistleblowers? That just seems just as perfectly valid of a career choice and a way to build a law practice as representing the defendants. So that seems like an unfair criticism in that respect. It also seems unfair because from the whistleblower perspective, right? I think one of the reasons people say it's okay that there's this revolving door between the SEC and private practice as well. Corporate defendants deserve good representation, right? It's scary when the SEC comes calling. It is the government. They deserve to have competent counsel represent them. And who is more competent to help a client, a company navigate, an SEC investigation than somebody that worked at the SEC? That's a valid, way of thinking about it. But then shouldn't the whistleblower also get the same, way of thinking? If you're a whistleblower and you're really scared about potentially blowing the whistle going forward, and navigating the process that we were talking about with the SEC in terms of the whistleblower program, you might want to have competent counsel help you. And who better to help you go through the process than people who have been at the SEC and know how the program works? And so I think we just think that whistleblowers deserve competent counsel, people that perhaps used to work with the SEC, no less than the corporate defendants do.
Right. And it makes sense that the more successful whistleblowers would be represented by an attorney, whether or not they've been at the SEC before, but because that is just the way that it works in the legal system, right? Like anybody who is represented by counsel has a better chance of having a case be successful than not. And as you mentioned, there's an obvious revolving door between former government people and big defense firms. So the fact that these people come out of the SEC and want to go help the good be lauded. And obviously it's a bad business practice if you think like you're going to go leave the SEC and just, obviously just make a ton of money doing this work because you've been at the SEC before, right? Because if you've been at the SEC before, you know that these cases take a very, very long time. There's no guarantee of anything like that. And that, if you were really going to go into this just for to bankroll yourself, you're going to go to the other side here.
That's exactly right. That's a really important point. I think another criticism of the program is that it's just doling out money to whistleblowers and their attorneys, and that's not it at all. The standards for a whistleblower award are, circumscribed by statute. You have to provide original information that leads to a successful enforcement action where the SEC obtains over $1 million of sanctions. And of course, all those things are entirely speculative when you're first going to the SEC and bringing the tip, bringing the allegations. So there's that. And then there's also the case that it just may turn out that the SEC doesn't think that you really did bring information that led to the award, And so my point is the SEC, as I said before, issues orders granting whistleblower awards. It also issues orders denying whistleblower awards, right? Both things happen. People go to the SEC after the notice of covered action that I talked to you about before, submit an application for award. Sometimes the SEC grants the application, and sometimes it doesn't. And so it's entirely speculative. Even if you get to the point where a case has been brought and you get to the point where you're making an application for award, whether you're actually going to be successful in getting an award.
Right. Well, anything else you want to add about, recent previous enforcement, what you see for potentially the future? I know that's a little uncertain right now, but anything else about the program you wanted to speak to?
Everything is uncertain right now. I think just how underappreciated the program is. We touched on this a little bit. You said something that I think is really important, that the program helps the SEC get information and identify wrongdoing that it otherwise wouldn't get, right? That's really why the program exists, to incentivize whistleblowers, and why it ends up giving awards to whistleblowers. Someone might think, well, why is he just giving money to these people? What's the incentive? And the incentive is lots of times, even the SEC, with the resource that it has, can't figure out what's going on at the company because they're not at the company. And so, it needs somebody who is at the company that is in a position to say, wait a second, this isn't right, to come forward. And I'm not sure that point is really appreciated. You have somebody who's like, oh my God, I can't believe this is happening. I need to tell somebody. But if I do that, I might lose my job. Well, okay, but if I do that, I might lose my job. But this seems pretty bad. This seems like the SEC should get involved. If it gets involved, I may be compensated, essentially, back pay for, being fired for blowing the whistle. Maybe I'll come forward. And from the SEC's perspective, it's like, well, we'd never be able to shed a light on what's going on unless these people come forward. That's really the crux of it.
Absolutely. I think it's very important, I think now more than ever, for private citizens to step up and report these things to the government and supplement the resources of the government now. And hopefully we'll see that continuing going forward. Thank you so much, Ben, for joining me today on Fraud in America. Any last words, or we are all good here?
No, we're all good, but thank you so much for having me and talking about the report, because one of the reasons we put it out is to try to let people know just how important the SEC Whistleblower Program is.
And it was a great report. I appreciate it very much. We all on this whistleblower bar have read it and think it's very useful, very helpful, and we would like to get the word out to the public. So, public, this is the SEC Whistleblower Program. It's important and it's working. So continue to submit those tips. And thank you so much again, Ben, for being here. Thanks for joining us on Fraud in America. Thanks to Getnick Law for sponsoring our program. And I'll see you next time.
Our annual sponsor is Getnick Law, a boutique Manhattan law firm dedicated to fighting fraud and promoting business integrity. Learn more about the firm at www.getnicklaw.com. If you believe you've witnessed fraud against the government or on the financial markets, or want to learn more about the laws that exist to fight fraud, visit TAF.org, where you can find a directory of whistleblower attorneys who work across the country. On our website, you can find information about the nation's whistleblower laws and programs and a way to donate to our organization as we continue to fight attacks on whistleblowers and these laws. Fraud in America is presented by the Anti-Fraud Coalition. Jacqueline DeMar is our host. James King is our executive producer. The website for Fraud in America was designed by Wide Eye Creative. Our artwork is by PPA Agency, and our theme song is by Spatial Relations.